Greetings, ladies and gentlemen. So today I want us to shift our attention to defamation. And in this video, we are going to define defamation. We are going to also discuss the types of defamation. And finally, we are going to look at the elements of defamation. So, what is defamation? Defamation is the publication of an untrue statement which lowers the claimant in the estimation of right-thinking members of society, hence causing them to be shunned or avoided. And this definition, the authority for this is the case of Sim versus Stretch, which is a 1936 case. Now, it's important for us to realize that defamation protects reputation, but it has to be balanced with freedom of expression, and it has also to be balanced with the right to private life. Now, what are some of the types of defamation? Now, we have two types of defamation. We have libel and we have slander. And what is the difference between the two? So, in terms of the form, libel is permanent, but slander is temporary. Now, in terms of the examples, libel is usually in writing, it is in film, it is in broadcast, it is in pictures. But slander is usually spoken words or sometimes gestures. Now, in terms of the classification of law, libel is a tort, but sometimes it can also be a crime. But when it comes to slander, slander is a tort only. Now, when it comes to the proof of damage, under libel, the proof of damage is not required. But under slander, proof of damage is required, except where you have exceptions. And we are going to talk about the exceptions where slander is actionable per se. In terms of actionability, libel is actionable per se. In other words, there is no need to prove special damages. But slander is not actionable per se. In other words, it requires proof of special damage. Now, what are some of the exceptions where slander is actionable per se? Now, normally slander requires proof of financial loss, except where the statement alleges four things. And the first thing is where you have commission of imprisonable crime. Number two, where you have contagious disease. Number three, where you have unfitness for profession. And number four, where you have formerly what we used to call unchastity in women. But this has now been repealed. So if you look at, for example, the first situation where slander requires does not require proof of special damage, and I'm talking about the imputation of a crime punishable by imprisonment, we have the case of Helwig versus Michel, which is a 1910 case. And the facts of this case were that the defendant falsely accused the claimant of committing a criminal offense punishable by imprisonment. And the issue in this case was whether spoken accusation of crime amounts to actionable slander without proof of damage. And the rule is that imputation of imprisonable crime is an equivalent of actionable per se. So the application of this case was that accusing someone of theft damages reputation immediately. So the conclusion of the case was that the court held that slander is actionable per se without proof of special damage where there is imputation of imprisonable crime. Now, the second situation where you have an exception where slander is actionable per se is where you have imputation of a contagious disease. And here we have the case of Bloodworth versus Gray, which is an 1844 case. Now, the facts of this case were that the claimant was falsely accused of having a venereal or a sexual transmitted disease. And the issue in this case was whether alleging contagious disease constitutes slander per se. And the rule was that imputation of contagious disease is equal to actionable without proof of damage. And the application of this case was that such statements socially exclude victims from society. The conclusion of the case, the claimant succeeded without proving special damage. Now, the third exceptions where slander is actionable per se is where you have imputation of unfitness to profession or unfitness to trade. And here we have the case of John versus Jones. And the facts of this case was that a headmaster of a school was accused of adultery. And the issue was whether adultery allegation affects professional capacity. And the rule was that only statements directly affecting professional competence qualify. So the application of the case was that adultery was unrelated to professional duties. So the conclusion of the case was that it was not actionable per se. Now, I want us to shift our attention to the elements of defamation. Now, for a claimant to succeed when it comes to defamation, a claimant must prove a number of things. Number one, a claimant must prove that the statement was defamatory. Secondly, the claimant has to prove that the statement referred to the claimant. And thirdly, the claimant must prove that the statement was published. So I want us to look at the first element where we are saying the statement must be defamatory. And we are going to look at the defamatory statement. Now, remember we have said that the definition of defamation, it simply refers to a statement which lowers the claimant in the eyes of right-thinking members of society. And the authority for this is the case of Sim versus Stretch, which is a 1936 case. And the facts of this case were that the claimant alleged statement damaged reputation. And the issue was, what is the meaning of a defamatory statement? And the rule in this case was that defamation occurs when reputation lowered before right-thinking members of society, causing the claimant to be shunned or avoided. So the application of this case was that the court applied objective, reasonable person standard. And the conclusion of the case was that this case established the modern definition of defamation. And when it comes to the objective test, we are talking about the right-thinking members of society. And here the authority for the objective test is the case of Byrne versus DN, 1937. Now, the facts of this case were that the claimant reported illegal gambling machine to police and was criticized. And so the issue was whether reporting illegality is defamatory. And the rule is that the statement must lower the claimant in the eyes of reasonable members of society. And the application of this case was that a reasonable person approves reporting crime. So the conclusion of this case was that the statement was not defamatory. Now, I want us to look at a situation where we have abuse. And we are going to look at abuse versus defamation. Now, legally speaking, mere insults usually are not defamatory, but there are exceptions. For example, if you look at the case of Barkov versus Burchill, which is a 1996 case, the facts of the case were that a journalist described an actor as hideous looking. Now, the issue was whether the insult amounted to defamation. And the rule in this case was that statement affecting professional reputation may be defamatory. And the application of this case was that the actor's appearance was relevant to his career. So the conclusion of the case was that the statement was capable of being defamatory. And I also want us to look at a situation where you have innuendo kind of defamation. And I'm talking about a situation where you have a hidden meaning known to a special audience, or where you have a statement with a double meaning. And the authority for this is the case of Tolley versus Fry, which is a 1931 case. And the facts of this case were that a golfer's image was used in an advert without consent. And the issue in this case was whether advertisement implied he accepted payment. And the rule in this case was that false implication affecting reputation is equivalent to defamatory innuendo. And the application of the case was that amateur golfers were unpaid, and so payment implied dishonesty. And the conclusion of the case was that advertisement was defamatory by innuendo. Now, that is the first element of defamation, that the statement must be defamatory in nature. Now, the second element of defamation is that the statement must refer to the claimant. Now, the statement must identify the claimant either directly, indirectly, or sometimes even accidentally. And here we have the case of Halton versus Jones, which is a 1910 case. And the facts of this case were that a newspaper invented a fictional character named Artemus Jones. Now, there was a real person with the same name who actually existed. And the issue here was whether accidental identification amounts to defamation. And the rule is that intention is unnecessary if reasonable readers believe statement refers to claimant. The application of this case was that the friends believed that the article referred to the claimant, and the conclusion of the case was that the publisher was actually held liable by the court. We also have another case of Newstead versus London Express Newspaper Limited, which is a 1940 case. And the facts of this case were that a newspaper reported conviction of another person with the same name as the claimant. And the issue here was whether true statement about someone else can be defamatory. And the rule was that liability arises if readers believe statement refers to claimant. The application of this case was that the readers assumed that the article referred to the claimant. The conclusion of the case was that defamation was actually established. Now, we also have situation where there is what we call group defamation. And whenever you have statements about large groups of people, such statements are really actionable. A good example is if you say all politicians are corrupt, or if you say all politicians are crooks. Here you're talking about a large group of people. So such statements are really actionable. And there is actually an authority for this. If you look at the case of NAFA versus London Express Newspaper Limited, the facts of this case was that a statement was made against a political group. And the issue was whether an individual member of that group could sue. And the rule was that group must be sufficiently small and identifiable. The application of this case was that the group was too large, and so the claim actually failed. Now, the third element of defamation is publication. The statement must be published. Now, publication simply means that the statement was communicated to a third party. It doesn't necessarily mean that the statement was published in printed form. And here we have different scenarios. We have what we call the spousal communication rule. And the authority for this is the case of Wenhart versus Morgan. And the facts of this case was that the defendant told spouse a defamatory statement. And the issue was whether communication between spouses equals publication. And the rule is that communication between spouses is not publication. And the application of this case is that marriage is treated as one legal unit. So the conclusion of this case, the court held that there was no publication. Now, we also have another scenario of publication where a letter is opened by a third party. And the authority for this is the case of Thierka versus Richardson, which is a 1962 case. And the facts of this case were that the defendant sent defamatory letter expecting the claimant to open it, but the husband opened it instead. And so the issue was whether this amounted to publication. And the rule is that publication occurs if third party access is foreseeable. And the application of this case was that the foreseeable spouse might open the letter. So the conclusion of the case was that publication was actually established. And there is a contrast case to the case I've just given, and it is the case of Hearth versus Hearth, which is a 1915 case. And the facts of the case were that a butler opened a letter not addressed to him. And the issue was whether this counted as publication. And the rule is that publication requires foreseeability. And the application of the case is that opening a letter was outside the butler's duties. And so the conclusion, the court held that there was no publication. Now, when it comes to publication again, we have something called the internet publication. And the authority for this is the case of Godfrey versus Demon Internet, which is a 1999 case. And the facts of this case was that a defamatory material was posted online. So the ISP failed to remove it after notice. And the issue was whether the ISP was liable as a publisher. And the rule of this case was that passive ISP is not liable unless aware and fails to remove the content. So the application of this case was that the ISP ignored the removal request. So the conclusion of the case was that the ISP became publisher and was liable. When it comes to publishing again, we also have the reputation rule. And the authority for this is the case of Duke of Brunswick versus Hammer, which is an 1849 case. And the facts of this case was that an old defamatory article was applied again years later. And the issue was whether fresh supply counts as new publication. And the rule is that each publication creates a new course of action. And the application of this case was that providing copy counted as new publication, and the conclusion of the case was that a fresh claim was actually allowed. Now, that is all about the elements of defamation, but it is also important for us to realize that when it comes to slander, there is what we call the remoteness of damage in slander. And the authority for this is the case of Alsop versus Alsop, which is an 1865 case. And the facts of this case were that a claimant suffered illness after slander. And the issue was whether illness qualifies as special damage. And the rule is that damage must be direct financial loss. The application of this case was that illness was too remote. So the conclusion of the case was that this claim actually failed because the damage was too remote. Another case for this is the case of Lynch versus Knight, which is an 1861 case. And the facts of this case were that a husband expelled a wife after hearing allegations. And the issue was whether consequence counts as special damage. And the rule was that laws must be legally recognized financial harm. And the application of this case was that marital separation is too remote. So the conclusion, the claim actually failed. We also have something called repetition liability when it comes to defamation, and the authority for this is the case of Cutler versus McPhail. And this rule established that the original speaker is liable if repetition is foreseeable. So that is all I have for you guys today as far as defamation is concerned. Remember, we've defined defamation, we've discussed the two types of defamation, and we have talked about the element of defamation. So that is all I have for you for now. In our next lesson, we are going to talk about the defenses of defamation. May God bless you. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.